All right, this is Rudy. It's June the 20th, and there was a blockbuster document. It was 66 pages. It covered the tie-in with Ted Stevens and the Polar Pen team, and how corrupt the Department of Justice is, the Office of Public Integrity. I sent those 66 pages to Schaeffer Cox, and he wrote 6 pages of comments regarding that document. That document was put together by a group that goes by Project for Government Reform Digital University. So here's what Schaeffer Cox wrote, and you can download both the original 66-page document as well as I scanned in all 6 pages from Schaeffer Cox. So you can download Schaeffer Cox's comments, and I put those in Schaeffer Cox's DropBox, and I'll put that link in the description bar as well as the comments section. So he says, what's still needed? Page number 2. You may want to add the 2009 FBI reports that more or less say we need to find a way to shut this guy up. On page 7, it said add the 9th Circuit Betty Fletcher slam of Botini/Polar Pen for hiding evidence. U.S. versus Co-Ring 637 F.3D 895. All right, page 13. FBI agent Chad Joy was investigated and fired Botini for blowing the whistle. Schulke report, page 40 and 155. Page 22. Cox visit to Fort Wainwright MP station. The FBI showed up 5 minutes after Cox left the MP station, not the next day. It was the U.S. Marshals who showed up the next day. Also, Cox had worked at Fort Wainwright for a few years, so going there seemed natural. Page 23. The Golden Valley Electric guys like Lance Roberts and others, who the FBI told boogeyman rumors to about Cox, knew Cox because Cox did right-of-way maintenance and right-of-way maintenance for power lines. They knew Cox was a good person. They referred work to each other and coordinated jobs. When the crews were working on power lines on the Cox's side of town, they would stop at Cox's home and Cox would make them lunch. The FBI did not consider this before they went around spreading lies. Page 26. The threats to get Gibson fired if he testified for the defense were very explicit. Follow up with him on this. Also, several MPs took the FBI's warning and refused to testify. This severely hurt the defense, but those MPs kept their jobs. Page 29. Informants tried to goad Cox into planning acts of violence in response to the pending efforts by OCS to remove his son Seth. Add word pending. Page 30. Point out the AUSA Steve Cooper came to trial to testify for the defense, but when asked about the conversation where Cox took him to lunch and warned him that Fulton and Bennett were pushing for senseless violence, Scrocky objected and the yes-man judge would not let Cooper testify further. See docket 643, filed 8/13/13, page 7 through 10, Cooper direct. Page 31. After describing the two-tier operation, i.e. threaten Seth to create the motive and then send in Fulton to supply the means, you need to point out that Fulton and Bennett resorted to violent coercion, not after the fact, but while OCS was hunting us down, looking for Seth, refusing to follow their own policies, stonewalling our lawyer, RJ, and before we could get into court about it. Marty and Schaeffer were scrambling to peaceably resolve the issue. The feds were scrambling to stampede Cox into a crime of passion and desperation to protect his child from politically driven FBI/OCS aggression. Have OJ get you the transcripts or the audio CD of the hearing where it all gets resolved. It all came out on the record. Rowley may have it too. It's supposed to be sealed. Page 31. J.R. Olson was not a Hell's Angel. He was only a prospect. with a Hell's Angel tattoo, HA tattoo. Page 31. The FBI informants never pushed Cox to plot revenge. They pushed to take out the ones who were coming to take Seth. After that failed and it was resolved by RJ in court, they pushed for a preemptive strike on the ones who were coming to get you, Cox. That's when Cox left. Page 35, comment page 8. The jury only had about 90 minutes of audios, not 5 hours. And those 90 minutes were made up of 30-second to 2-minute clips that omitted all exculpatory sections and were out of context so as to be misleading. Page 36. Trumped up weapons charge trial was February the 14th, not 19th. Page 36. Scrocky not only lied to the jury, he lied and gave false statements that we can prove he knew were false at the time he gave them to the judge to sway his decision on pretrial motions. Read Scrocky's knowing and intentional acts of highly calculated preemptive deceit at 3:11-CR-00022-RJB, docket 593, filed 3/18/13, page 52 through 54, where he claims only 2 informants. Find Scrocky lies to the judge at 3:11-CR-00022-RJB, docket 365, filed May the 3rd, 2012, coincidentally on page 52 through 58. Also at docket 366, page 87 and 125. Page 37. Be clear when you say that Cox didn't show up for the 2/14/2011 trumped-up weapons charge trial. The reason he could not show up was Fulton's death threat ultimatum made against Cox, coupled with his promise to go on a rampage through Fairbanks, triggered by Cox going to court. Page 37. Unbeknownst to Schaeffer, Olson disabled their vehicle. Is not accurate. Cox knew Olson took the battery. He never was stranded. Olson said he was going to get a replacement, but never did. Page 37. You need to point out that Cox and his family weren't on the lam. They were being kept against their will for 21 days in an attic by Olson, who had disabled their car, promised the false trucker, and came by every day to remind the Cox family to stay hidden because Fulton and Bennett were searching all over town for them, to which Cox exclaimed, "To kill me." I believe this "kill me" statement was on February 21st or maybe March 4th. You'll have to ask Rowley. There may be some clues in the objections to the pre-sentence report 3:11-CR-00022-RJB, docket 535, filed 12/26/2012. It's under seal, but Maria has it. Page 3 of comments, but page 37 of the timeline. Cox and his family had no intention to go to Montana. They were headed to Canada. Page 37. It's Coleman Barney, not Barney Coleman. Barney is the last name. Page 38. Cox and Barney never agreed to buy the silencers Olson was pushing. But even if they had, it still would not be illegal because Olson said the silencers were legit and for sale by a licensed Class 3 dealer. See 3:11-11 audios in Olson's truck and Scrocky's admission followed by a lie at docket 365, page 54. But despite all this, Cox still told Olson to send the stuff back to whoever he got it from. Page 39. The armed security detail at KJNP was on the same street as Aaron Bennett's house, about a quarter mile away. Bennett had said he would kill Cox for refusing to get on board with violently attacking the government. The security was for fear of Bennett. Page 39. February 12th, Cox made the decision not to appear at court because on February 6th, Olson had relayed Fulton's death threat ultimatum and said he planned to use court appearance as an excuse for violence. Cox had to no-show or risk setting Fulton into a rage. Cox had already told both AUSA Cooper and Trooper Ron Wall about Fulton and Bennett, and nothing happened. Cox's only options were fight or flight. For the sake of his family, Cox chose flight. Page 42. It is not correct to say that informant Olson recorded the entire conversation on 2/19-11. Olson had a recorder which he could turn on and off in his pocket, which he did. He would switch it off and then try to prime the conversation, then switch it on again. This way he could conceal the fact that he had always made the initial pitch. This is crooked, but we still uniformly rejected his suggestions. You can hear it stop and start. Also, the elapsed time on the recording is several minutes less than the time from turning it on, and when the meeting was over, it got turned off. This indicates a missing section. 42. LEO stands for Law Enforcement Officer, not elected officials. 43. Mike Anderson and the list of certain government individuals was not a hit list of people Cox wanted to murder. Actually, just the opposite is true. After OCS baselessly attacked Seth, and the MPs told Cox that the U.S. Marshals planned to kill him to fix the Schaeffer Cox problem, Cox asked several people, including Anderson, how many law enforcement agencies and personnel were in Fairbanks and who might be out to kill him and why. Cox simply wanted to figure out who was not corrupt in town, who he could trust, and who was going around bragging about how they were going to murder him. Here we have a case of the feds falsely accusing Cox of the very thing they themselves were doing, sneaking around, trying to set up an opportunity to gun down an innocent man just because he is a political rival. Nowhere ever does Cox say to kill people on or off a list. This is purely the government projecting their own guilt. Page 4 of comments, page 44 of timeline. Here is the story under prison. Here the story under prison reads, there was no legitimate law enforcement purpose in electronically recording, investigating, surveilling, and attempting to rig illegal transactions with Schaeffer Cox in response to his protected free speech that was critical of the government. You need to add the transcript of FBI agent Westerhouse when Bill Fulton recorded him and asked him, so why are you going after Schaeffer Cox? And Westerhouse replies, without missing a beat, because he's been talking too much smack about the government. Rolyport has this clip, so does Maria Rensel. Page 48 on the timeline. Referring to Norm Olson and some other guy named Ray Southwell is Norm's best friend and neighbor. Page 54 in the timeline. Kleingate. K-L-E-I-N-E. K-L-E-I-N. Kleingate. You point out that the government never even called Fulton as a witness. They also never called S.A. Sandra Klein, even though she was a supervisor of the Joint Terrorism Task Force, also known as JTTF, docket 365, page 72. And I believe the real case agent, not S.A. Sutherland, as we were led to believe. It was her and Fulton's case. Why all of a sudden exclude both of them from the process? To help hide evidence. This habit is exposed in the Schulke report, which scolds these very prosecutors for their entrenched pattern and practice of weaseling their way out of their disclosure obligations anytime they come up against evidence that either help the defendant or hurt the prosecution. They did this by cooking up ridiculously hokey and legally unsound excuses to tell to themselves about why it was okay for them not to turn over evidence that any reasonable mind knows the law requires to be turned over. Among the goofy internal excuses were the evidence of Bill Allen soliciting perjury in a related case was based mostly on attorney argument, so it's not subject to disclosure. And that evidence shows innocence under this theory of the case, but not necessarily under this other theory of the case, so therefore in our judgment it is immaterial. So we're not going to disclose it. And we are not planning to call that agent to testify in our case in chief, so any evidence related to her that hurts the prosecution or helps the defense is no longer material. And the evidence of misconduct is beyond the scope of questioning. We, the government, plan to examine this agent on, so it's no longer material. None of these types of excuses held water once they were no longer secret. The judge didn't buy them, OPR didn't buy them, Schulke didn't buy them. The only people who bought them were the Polar Pen gangsters, who used them as a wink and nod to each other as they illegally hid evidence so they could send innocent people who they knew were innocent to prison. We only got a tiny bit of discovery related to Klein and Fulton, all of which were incidental to discovery coming from other agents and informants. And even that had whole sections blacked out. The motherlode of discovery about Klein and Fulton, what evidence they collected, and what misconduct they engaged in, is still being illegally concealed. For a glimpse of the disingenuous excuses Scrocky, Lamoureux, and Bottini used to rationalize their crime of hiding evidence related to Klein and Fulton, see the following lies to the court. Docket 365, page 81 and 83, objection to question, when did the law enforcement start to focus on Mr. Vernon? Docket 366, page 144. Scrocky objects to question that would reveal Klein was observing Olson and Fulton in Anchorage on February the 4th, 2011. Docket 366, page 150. S.A. Sutherland, intentional ignorance of J.R. Olson's prior crimes. Docket 366, page 160. S.A. Sutherland leaves out J.R. Olson's conviction for evidence tampering when the judge asked him a direct question. Page 5 of 6. Docket 594, page 78 through 83, AUSA Miss Lamoureux claims all evidence relating to Fulton and Klein is irrelevant because the government no longer plans to call the witnesses. Docket 594, page 87, Lamoureux says the government wants the defense to give some sort of proffer regarding these legitimate reasons to call Fulton as a witness before he can be called. They are just hiding their sins. Also note that on page 88, the judge says regarding Fulton, I don't know who that is. Is he like, I don't care who it is? Is he like within our custody and control? Like within your custody and control? Like a federal agent or a prisoner in prison? Or is he just some citizen? Then Lamoureux lies to the judge. She starts to tell the truth that he was a confidential source for Agent Klein, but didn't finish her sentence. Instead, she switches to the lie. He is a private citizen. This is not true. He is working this case under the FBI direction and on the government's payroll. What Mr. Lamoureux did was lie to the judge so as to deprive him of the facts that were essential for him to make a proper and informed determination as to whether or not those 60 out of 80 redacted pages were relevant to the case. The judge ruled to leave the 60 redacted pages redacted, but he did so thinking that Fulton was just a private citizen. For all the judge knew, Fulton could be Klein's significant other, in which case nothing they talked about should be relevant at all. However, Fulton was Klein's informant, and Klein was the supervisor of the JTTF. So almost anything they did or didn't say is relevant in one way or another. But whatever is in those redactions is bad enough for the government that the Polar Pen Gang decided to drop the supervising agent and the main informant as witnesses, then lie to the judge to keep from having to hand it over. But dropping Fulton and Klein and witnesses does not make their misconduct during the investigation irrelevant. Unless, of course, you are a Polar Pen gangster who make up your own crooked rules as you go and cross your fingers to not get caught. Lamoureux did mumble in a low voice that he was an informant in this case, but she said it was so quiet that the hard of hearing judge didn't hear it. She surely said, he is a private citizen, loud and clear, looking the judge in the eyes, and in response to the judge's direct question, is he just some private citizen? The judge did not hear Lamoureux's muffled post-lie confession that Fulton was an informant. Instead, he thought she was asking him for a specific ruling and indicated this was his question that followed her paper muffling. You should read all of the docket 594 and see how many times the judge says he can't hear or understand that. Wow, that's amazing. Lamoureux, you're an evil, evil person. Page 55. BU equals Bureau, i.e. FBI. Page 56. When referencing Tea Party targeting, you may want to touch on the because he's talking smack about the government comment from FBI Westerhouse, who works for this very same public integrity unit of DOJ you refer to. Tie this in. See 3:11-CR-00022-RJB. Docket 365, filed 5/3/12, page 130. Westerhouse, direct, I investigate public corruption, and I was in Washington, D.C. He also is the agent who filed the time machine warrant on February 19, 2011, early in the morning, which impossibly claimed to describe events that happened later that day. Show here that J. Bottini, page 56. Show here that J. Bottini prosecuted Stevens, was co-prosecutor on the Cox case. See docket 365, pages 3 and 4. Timeline, page 57, page 6. Under Public Integrity section, a cancer of corruption, you may want to track down Senator Lisa Murkowski's comments on NPR where she said these prosecutors are cheats and liars. And I think everyone is going to be shocked when the truth finally comes out in the Schaeffer Cox case. Page 64. Hopefully this will tie back into Schaeffer Cox sitting in a secret CMU prison, rotting away as an innocent man, and call for his release and punishment of the crooks who put him there. Amen to that, Schaeffer. Amen to that.